Hello and welcome to this Facebook Live discussion. I'm Siddharth Varadarajan and this is my colleague Anuj Srivas. Today is a great day, a momentous day, a dramatic day as far as the rights of citizens are concerned. The Supreme Court today delivered its much awaited ruling on the question of the right to privacy. This was a 9-judge bench. Remember, the number was chosen essentially because there have been two previous judgments of the Supreme Court over the last 3 decades. One was a 6-judge bench, one was an 8-judge bench that in a way prescribed limitations on the right to privacy. So this question was once again agitated by before the court by those who are opposing the Aadhaar scheme of the government, the UID system, and a 9-judge bench was formed to address the question of whether privacy is a fundamental right. In many ways, the origin of this bench, ironically, came from a suggestion by the Attorney General, the then Attorney General of India, Mukul Rohatgi, who was arguing against the claims of the anti-Aadhaar people that privacy rights were somehow being violated. And he took the view that privacy was not a fundamental right. And it was largely as a result of that line of argumentation that a special bench was constituted to actually go into this matter, headed by the Chief Justice, but with 8 other judges. And the judgment today, 557 or 67 pages in all, but consisting of 6 separate but concurring judgments. The lead judgment has 4 judges signing on to it, including Chief Justice Keher, and then you have separate concurring judgments, all of which essentially reach the same conclusion that privacy is a fundamental right of the citizen, and overturning or overruling existing judgments of the Supreme Court that had prescribed limitations on this right insofar as they dealt with this issue of right to privacy. This is a huge judgment, a momentous judgment. It has numerous implications because by describing in this way the right to privacy as a fundamental right, the status of a number of other laws, the government policies that could arguably be deemed to infringe on the right to privacy come under a cloud. Some of the judges in their separate judgments have alluded to issues that would immediately be affected by this judgment. For example, the criminalization of homosexuality by Section 377 of the Indian Penal Code. Certainly a huge question mark now hangs over the future of 377, although this is again an issue that a separate bench is going to deal with. So it's not as if the law gets overturned, but certainly a big blow to all of those who are still trying to cling on to this Victorian definition of morality and the rights of citizens in criminalizing homosexuality. And of course, implications for Aadhaar are quite not apparent, not explicitly there, but this judgment does have implications. So what we're going to do in the next half an hour is my colleague and I will try to walk through the judgment and its implications. Anuj has been tracking the Aadhaar debate and the privacy debate right from day one, and he was present in a number of the court hearings when this issue was argued by really a stellar cast of judges, of lawyers representing both sides. And let's start, Anuj, with the kind of the big question which everybody wants to know. This judgment was an outgrowth of the dispute of Aadhaar. Is there any clarity on what this would mean now for the Aadhaar debate?
Yeah. So I think, as you pointed out, the breadth of this judgment is sort of astounding. They address a number of things, and I've heard a number of lawyers and people start to refer to as a new Charter of Rights. But the single most significant implication for the Aadhaar debate is that the gridlock, sort of the deadlock in the Supreme Court over ruling on the constitutional validity of the Aadhaar case, that is going to start moving ahead right now. So back in July, which is when the 5-judge bench for to rule on the constitutional validity of Aadhaar, that was set up. It was, as you pointed out, set aside for a moment to finally argue on the final point of whether or not privacy is a fundamental right. So now that this is decided, it will finally go back to the same 5-judge bench, or perhaps a new 3-judge bench will be constituted to drill down into the finer points of whether the Aadhaar case counts as a reasonable restriction on the fundamental right to privacy, and whether the state's ability to provide welfare, for instance, is adequately protected as a result of this. So throughout the judgment, throughout the six opinions of the judges, there are references to Aadhaar, especially when talking about what sort of reasonable test you could apply to a fundamental right of privacy. But all of the judges have been very careful, to repeatedly restate, saying that we're not here to rule on Aadhaar, we're only here to rule on the validity of privacy as a fundamental right. So hopefully,
In fact, I did a word search, and the word Aadhaar explicitly figures only 4 or 5 times
exactly.
in the judgment.
So, I mean, because they've been very careful, because this is what these were some of the concerns expressed by both sides, the pro-Aadhaar and pro-Aadhaar camp, as well as the government in the run-up to this case. They wanted to make it very clear that, they should not be ruling on the specifics of Aadhaar, and when people tried to bring up the examples of UID during this thing, also it was quite shut down. So what we can hope for now is that this judgment has come through. In the next, I think, I was speaking to some of the petitioners today. In the next 6 to 8 weeks, we can hope a new judge, a bench of 3 or 5 justices will be set up to tackle the Aadhaar issue. But certainly, I mean, it's a huge victory for privacy and personal rights, and that's to not take away from that.
Now, the government, there's a statement from Ravi Shankar Prasad that we welcome. Let me just read out what a colleague just sent me, that government welcomes the judgment. Government has been of the view, particularly with regard to Aadhaar, that the right to privacy should be a fundamental right. I believe this is the tweet by Ravi Shankar Prasad. Is the government making a virtue out of necessity here? Because the fact is that they went to court saying privacy is not a fundamental right.
Exactly. So, I mean, 2 attorney generals have argued this case over the last 3 months. And many of their arguments, for instance, Mukul Rohatgi's argument that privacy is too amorphous to be a fundamental right, this Justice Nariman has, dismantled it with, specific precision. So now, I mean, at this point, the government has no right but to accept this and perhaps point to some of their other developments, setting up a data protection council and whatnot. But I mean, many of the arguments that have been proposed by the government with regard to privacy not being a fundamental right have been sort of really taken down as part of this judgment.
Let's kind of look at individual components, and I just want to stick with Aadhaar for a minute, because one of the in the concluding sections of the judgment authored by 4 judges, including Chief Justice Keher. So this is the lead judgment, as it were, written by Justice Chandrachud. Makes a strong, in his concluding paragraphs, makes a strong plea for the need for a data protection regime or law. And within that context, there is some very brief discussion on what would be valid grounds for the government to collect information or data. And one of the issues mentioned there, one of the grounds mentioned there, is to prevent the dissipation of welfare benefits. Now, that phrase in some ways is an echo of the government's own arguments before the court, particularly, maybe not in the privacy case, but in certainly the Aadhaar case, that one of the major reasons that we've launched Aadhaar is to prevent so-called dissipation of welfare benefits. The idea that by fixing the identity of a recipient, we can prevent leakages from happening. Do you think that this, the use of this phrase in at least one of the 6 judgments, but one authored by 4 judges, provides a leg on which the government may then perhaps extend an argument that Aadhaar, data collection for Aadhaar, would not violate the court's ruling on this?
Correct, right. So, I mean, I think to look at this is, so as we know that since it's been declared a fundamental right, all fundamental rights in India, there are some amount of reasonable restrictions that one can apply on it. And they've set out a sort of a 3-finger or 3-prong test as to what restrictions are reasonable on privacy. So one is that any law that places restrictions on privacy must be fair, reasonable, and compelling state interest. So I think to a certain extent they've left, I don't want to call it a backdoor, but there are enough references to show that the right of the state to effectively and without loss economically efficiently deliver subsidies is sort of a compelling state interest that could provide a restriction on privacy. But then again, so there are the way the state argued this case is sort of divided into 2 arguments. One, does India's poorest have a right to privacy, and in fact should they be willing to give it up because of this? And 2, does Aadhaar as a welfare delivery system count as a compelling state interest? So, to the first part of this argument, for instance, I think Justice Chalameshwar, clearly says that privacy is not an elitist concern.
Yeah.
So it's not that the poor have the poor have either no choice or are actually really willing to give up
That's right.
the right dignity and the right to life and
Yeah.
liberty in exchange for a strong welfare state. So that argument, I don't think it's really, they're not throwing any bones towards the government when it comes to that. But as you mentioned, with regard to Aadhaar acting as a welfare mechanism and whether that can be construed as a reasonable restriction or a method by which privacy can be hampered down, that is still...
In fact, I ran that paragraph by one of the anti-Aadhaar activists who have been focusing a lot on the fact that Aadhaar, rather than preventing leakages and wastage, in many documented cases has actually led to the denial of benefits to the intended beneficiaries. And she was saying that, look, if anything, the argument of Aadhaar or the collection of data for Aadhaar because of the welfare distribution program of the government, if one were to go down that path, one would actually have to strenuously argue that Aadhaar violates not just the right to privacy but also the right to life, because it denies people access to welfare schemes that would be life-sustaining in some way.
Yeah.
So I think that what shape or form the argument will, or the manner in which it evolves in the Aadhaar bench is anybody's guess at this stage.
Correct, that's true.
But certainly the refutation of the government's core argument that privacy cannot be considered a fundamental right and that it's an elitist concept. Mukul Rohatgi, strongly argued that point, in fact saying that it was a Western concept, elitist concept. And I've heard people say how many Indian languages don't have a neat or crisp word for privacy. In fact, we were scrambling ourselves today for the wire Urdu as to what the best word for privacy in Urdu might be. Similarly, Hindi, Nijta, not a word that people use in daily discourse. But I think that issue, in a way, has been settled, that privacy is very much a concept that belongs to and inheres and is valuable for every citizen.
That's true.
And that provides a basis now for the Aadhaar bench to consider all the issues that Aadhaar comes up with. Let's look at another topic now, which has led to a lot of excitement and a lot of, shall we say, optimism about how the 377 issue, the fact that Indian law still criminalizes homosexuality, which is clearly an act of that would it would be criminalizing acts of intimacy by consenting adults in the privacy of their own home. I noticed that at least 3 of the 6 concurrent judgments make explicit reference either to how Section 377 is violative of the right to privacy. They have criticized the Supreme Court's own two-judge bench ruling of December 2013, which by Justice Singhvi, which in a way upheld 377, and have spoken. I think it was Justice Bobde who says that sexual orientation and intimacy, these are fundamental, these are essential to privacy rights, and that you can't have those rights can't be violated. I think this has set the stage for the Supreme Court, which is anyway supposed to be taking a fresh look at the Singhvi judgment through a curative petition. In light of this 9-judge bench ruling, I think, although they also say that this is for that bench to decide, but the burden or the weight of this 9-judge bench is such that it's going to be hard for that curative petition bench to ignore this.
I think that's, so I mean, just so that for our viewers who are not familiar with the history of the Section 377, what happened was, I think it was in 2009 is when the Delhi High Court read it down and said that it can't be construed. But then this went back. The case is Suresh Kumar Kaushal versus the Naz Foundation, and so in December 2013, the Supreme Court they looked, in fact. So one of the arguments against in favor of decriminalizing homosexual sexual activities was that it violated, a right to privacy, and you're drawing on international precedent and whatnot. And what they explicitly refer to here in this judgment is that they look at Justice Singhvi's judgment, who said that Section 377 has been applied to only a minuscule
section of the population.
Of the population, and so this is not, it's not a sustainable basis for saying that it
violates the rights of all. Exactly.
Correct. Exactly. And so then they go really quite hammer and tongs against this, for around 500, 600 words before, of course, saying that yes, this is still up for consideration in the Supreme Court, and it'll eventually be decided then. But
and the fact that it's the 4 judges who lent their name, including Justice Keher, Chief Justice Keher, pretty much ridiculing the logic of the Singhvi bench, essentially on this issue of, just because a right is violated for a section that may be a tiny minority does not mean that it's not a right. And they've also argued against Singhvi's, I think he uses the phrase so-called right,
correct,
saying that there's no such thing as a so-called right. And I think this is really something quite dramatic.
Yeah.
And in a way, the future of the struggle against the criminalization of homosexuality, the course is set, and barring any dramatic change in the court's outlook, or I think it's pretty much I would say a done deal. Although the judges are very careful to say that a decision on that rests with the bench, which is going to be hearing the curative petition.
Correct, that's true. And so the other discordant note, as they call it in the judgment, is the ADM Jabalpur case, which at that point it was a matter that came up before the court, wherein an order issued by the President of India suspended the right of any Indian citizen to move the court, if their the right to personal life and liberty had been infringed upon. And they specifically go after this as well, and they say that it's been implied that the decision no longer really has any favor, or doesn't have a lot of legal logic behind it. But first time we're expressly stating that it doesn't, and that primarily fundamental rights predate the Constitution, predates the state. There's nothing that it doesn't come directly through us or the Constitution. So both two sort of important legal implications, barring just the right to privacy. That sort of.
If I just elaborate a little bit for again the benefit of our viewers. So ADM Jabalpur is this landmark and rather horrible judgment from the Supreme Court during the emergency, where they upheld, in a way, they declared that there is no fundamental right to life in a condition when emergency is imposed, and this was overturned through an amendment to the Constitution by after the end of the emergency, and but it was never explicitly overruled as a judgment of the court, and we've had several judges in their concurring judgments essentially attack ADM Jabalpur and say that this is now being explicitly overturned, and that the right to life is not a right that the state can take away even under conditions of emergency. It would seem to be commonsensical. In a democracy, it's astonishing that it's taken so long for this to be explicitly repudiated, and I'm glad that finally it's happened, even though it's largely an academic exercise.
Correct.
But nevertheless, it's important. There's a question that's come in from one of our viewers. Atanu Bhattacharya says, if the right to privacy is a fundamental right, then all the organizations like Google, Facebook, WhatsApp, LinkedIn, etc. have to change their policies immediately. They cannot be tracking and using individual data for their own benefits. How do you think this is going to play out?
No, so I mean it's quite interesting. So one of the debates, both between the anti-Aadhaar camp and the government in the run-up to this thing, was a sort of fear as to how the nine-judge bench should define the right to privacy. So one, we have now a fundamental right to privacy, but what is very less clear is how this should be applied. So for instance, because this case, over the 1 week of hearings, it had no case context. It had no specific social or environmental or political or economic context with regard to that. Most cases that come up before the Supreme Court apply to a specific instance. So here we have, for instance, Justice Chalameswar, who tries to give a three-pronged definition to privacy, saying that it's freedom from unwanted stimuli, it's protection against intrusive observation, it's respecting one's personal life choices, and so on and so forth. So it's going to be very, very difficult to try to even guess how this is going to play out when it comes to massive data leaks, or the way Google and Facebook operate in India. This is just setting the foundation for many judgments and many cases that will come up before the court in the years to come. So it's quite difficult to track.
To assess that. There's also a question from It's vanished. There was a question anyway. I forget the name of the person who asked it, but they want to know what this would mean for the right to eat beef in one's own home. And I think this is a pretty interesting question. Yeah, this is from Andamani Abu Shafna. So eating beef also comes under this purview, question mark. Well, I think I believe one of the judges has actually made an explicit reference to food.
Correct.
And bringing that under the purview of privacy as it ought to be. The direct bearing I reckon this probably would have is on the Maharashtra government's appeal against the Bombay High Court striking down those sections of the toughened cow slaughter, anti-cow slaughter legislation of Maharashtra, which had criminalized not just the slaughter of cows and cattle, but also the possession of beef that you perhaps got from another state. And the implication was that, if you have acquired something and you want to consume it, then this should not be criminalized. So I think that once you declare privacy as a fundamental right, as we said at the start of this discussion, its implications on a number of policies and laws really need to be studied and teased out.
That's true. I think the most recent Supreme Court lawyer Karuna Nandi was saying that next Monday in front of the Delhi High Court, the marital rape case is going to start hearings, and so now with the fundamental right to privacy really emphasizing the right to bodily integrity and the right to informational determinism. So this will play a huge impact on the thing. But just quickly coming back to that the Google question, I just want to I don't want to sound like a Debbie Downer, but there are multiple judges and their opinions have really stressed upon the concept of national security and how it's a very reasonable restriction on privacy. In fact, Justice S. Call calls for what some privacy activists would probably say problematically for balancing the right to privacy with mass surveillance programs and so on and so forth. So I mean, this is not going to automatically change anything overnight, and especially when it comes to India has a long history of programs both by state, central government agencies of snooping and so on and so forth. So this is just the first step.
Correct.
Before we tackle those.
Correct. There's a question from Abid Shafi. The judgment says that individuals' right to privacy is fundamental, with reasonable restrictions. What could reasonable restrictions mean? What does privacy mean, and could it be subjective? I think this is again an excellent question, Mr. Shafi. My reading of the judgment, at least my cursory reading, and I can't pretend to have comprehensively read all 567 pages. Maybe you did better than me, but a couple of judges or a couple of the judgments attempted to answer the question that you're asking, where the right to privacy is traced to, let us say, Article 19, which is the right to free speech. The restrictions that could apply to the right to privacy would be those restrictions which are explicitly listed in Article 19. Public order, morality, incitement to violence, defamation, etc. Where, if we speak of Article 14 or Article 21, which is the right to life, the restrictions that are envisaged really are procedures established by law, due process, and these can, I think Justice Chalameshwar's judgment talks a little bit about how these restrictions are to be interpreted and whether a state can take an expansive or a narrow definition. And he says it really depends on case to case what the issues that are being agitated before the court would concern. And I think that how future benches interpret the reasonable restrictions is going to be crucial. I should add that in a second tweet from the law minister, IT minister Ravi Shankar Prasad, he says that on behalf of on behalf of Government of India, Attorney General also argued that the right to privacy is a part of fundamental rights with reasonable restrictions. So this is the government's line essentially would be, having lost on the issue of whether privacy is a fundamental right or not. Let's not forget that the opening gambit of Mukul Rohtgi was that it's not a fundamental right. You remember those headlines also. Today, of course, it is a fundamental right, but with reasonable restrictions. And the entire battleground would obviously be over what constitutes reasonable restrictions.
And ultimately, I think once the tire hits the road, this will start to be defined on a case-by-case basis. I think multiple judges have defer to this, and obviously the first and biggest case will be the other thing. But then they go on to talk about, for instance, when you have to give up tax information to the government. Yes, that's a reasonable restriction. You're expected to put up this information. But then they do go on a little bit further than that and address data protection, saying that, okay, after you are forced to give it up to the government, who should the government be allowed to give it to, and so on and so forth. So there are things like that. But ultimately, we will, over the next few years.
Right. Are there any other issues that you want to highlight at this stage?
No, I think this is primarily it. This is what I was
okay, before we sign off, I did want to alert readers to what I felt was a gratifying aspect of the judgment, which is that in both the judgment that the 4 judges sign on to, in other words, the Chandrachud judgment, as well as Rohinton Nariman's, the conception of rights that is elaborated is something that is, I wouldn't say completely new, because there are earlier judgments which talk of rights as an evolving concept, and that rights expand as the sphere of human activities expand. But in terms of the explicit articulation about this concept, that rights in some ways predate the Constitution, they don't derive from or spring from the Constitution embodies rights that inhere in humans as by dint of their being human. And as the sphere of human activity, I think Rohinton Nariman is explicit on this point when he says that the universe is ever expanding, human activity is ever expanding, and rights expand and fundamental rights expand in tandem with that expanding activity. And I think this is a very key concept, one that underlines the fact that rights are not static, rights expand, and governments have to, in a way, keep up with the fact that as human activities evolve and expand, what we take as our fundamental rights will also be expanding, and that the government has to be respectful of that, has to protect and uphold those rights. How the privacy judgment will play out in different spheres is something that we will see and monitor and bring to you. In the meantime, do visit the Wire Hindi and the Wire Urdu for details of the judgment, the separate judgments. What we've done is we've separated out this, we've broken down this 567-page document into the 6 separate but concurring judgments. It's easier for you to navigate, easier for you to read. I would urge as many of you as possible to read what is really a landmark judgment. This is a signature day in Indian jurisprudence, in Indian jurisprudential history, because you have such a dramatic and far-reaching verdict, one which is unanimously signed on to in its essential contours by a 9-judge bench. On that note, thank you very much for watching.